Residential Market Analysis and Highest and Best Use, Chapter 1, Market Fundamentals, page 44, Unique Properties. We have already mentioned that no two parcels of land are identical. The same cannot be said for improvements. Many so-called improvements are constructed as tract homes, which are very similar to each other. In fact, they may be identical, but are situated on different sites. The land is not the same, but the improvements are exactly the same construction, condition, size, etc. At the same time, we do have some unique properties that featured customized interiors and exteriors. These one-of-a-kind properties may not be reflective of the real estate predominant in the marketplace. They are said to be unique, and indeed they may be. The improvements, uniqueness, and the added amenities may enhance the property value. This kind of property is especially challenging for the appraiser due to the limited number of similar properties and comparable sales available for analysis. The costs incurred in the construction of the property in question may far outweigh the market's interpretation of value. The appraiser may relate the property being appraised to the demand in the marketplace for this type of property. Not only does the appraiser have to perform the analysis based upon the limited comparable sales available, but he or she must also analyze the demand for the property in that marketplace. Permanence of the land area. As stated earlier, land does not move. The land cannot be placed in another section of the community. The land is where it is. The appraiser may not have trouble finding similar comparable improvement sales, but the land will require a separate analysis due to the market factors of supply and demand. There is only so much land, and no two parcels are exactly the same. Restrictions on use of the land. When considering the effects of police power and other governmental regulations and private restrictions in place for the particular parcel of land, the appraiser is once again faced with the task of analyzing the restrictions which may limit the highest and best use of the land area. The allowable highest and best use of the parcel may affect the value regardless of demand in the marketplace. Private restrictions are those specific limitations that property owners place on the use of the land area. These private restrictions, commonly known as deed restrictions, act as insurance that the land will not be used for something offensive to the present and/or future property owners in the neighborhood of the subject property. The other restriction the appraiser must deal with is the developer's covenant, instituted at the time the land area was developed from vacant land to sites that were ready for a higher and better use. Covenants are the most restrictive of the restrictions in place for the land's use. These are the rules that will apply for the use of the land area in the residential subdivision, a commercial park, an industrial area, etc. Covenants may require a certain kind of building material to be used in the construction process, or allocate a minimum amount of required square footage per building depending on the number of stories constructed. There may be a restriction on the type of fencing used to enclose the property. There may be a stipulation for residential properties that garage doors will not be left open, or that the driveway must be a 5-and-1 Portland concrete pour and not less than 2 cars wide. It is up to the Homeowners Association, HOA, to police and enforce the rules for use of the property within the land area covered by the covenants. Most covenants have been recorded, and the appraiser must avail himself or herself of this information for an accurate analysis and opinion relative to the property's land value for this assignment. End of page. Page 45. Forms of ownership. The most common type of ownership is said to be fee simple. A fee simple estate is the best and most complete type of ownership one can have to a parcel of real estate. Simply put, all the rights of ownership are being transferred by deed to the new owner. All of the rights of ownership reflect back to the bundle of rights. Remember, slugger. The right to sell, the right to lease or rent, the right to use the property, the right to give the property away, the right to enter and leave the property, and the right to refuse any of these rights. We can also add the right of quiet enjoyment for the owner to be able to use and enjoy his or her property. As was stated earlier, the appraiser is normally valuing the rights of ownership for a given property. The appraiser is not normally valuing the real estate without the consideration of the rights of ownership. That is why it can be said the appraiser is concerned with the bundle of rights pertaining to the subject property. Most of the time, the appraiser is valuing the property in fee simple estate status with all those property rights intact. The appraiser must collect and verify all relevant data that would affect the value of the property. Once collected and verified, an analysis of the information must be accomplished to ascertain the impact, if any, on the overall property value. A property's legal owner and type of ownership may be obtained from the Public Records Department at the county level. A preliminary report of title may be obtainable from the financial institution holding the mortgage of the subject property. The preliminary report of the title will state the limitations of the title. The property deed will identify any deed restrictions for the use of the property. The property's title data may state the mineral rights were sold several years ago by a previous owner. The deed may indicate that alcoholic beverages cannot be sold or offered for sale on the property for a period of 20 years from a specified date. Are all of the property rights intact? Do these restrictions affect the property's value? How does the appraiser treat these restrictions? Can the appraiser accept this assignment? Sole owner, also known as ownership in severalty. This type of ownership indicates that the one person owns and holds title to the property. Concurrent ownership. This type of ownership includes 2 or more owners of the real estate concurrently. The rights of ownership may be undivided, or percentages of ownership may be specified in the deed. Some of the more common types of ownership are joint tenants with the right of survivorship. There are 2 or more owners of the property, and upon the death of one of the parties, his or her undivided share goes to the surviving party or parties. With joint tenancy, the owners do not have to be related or married to each other. Tenants in common. There are 2 or more owners of the property. Upon the passing of one of the owners, that owner's share passes to his or her heirs. There is no right of survivorship with tenancy in common. Unlike joint tenants, there can be unequal ownership shares. For example, if 3 people own a property as tenants in common, one person can own 50% share, the second person can own a 40% share, and the third person can own a 10% share. Tenancy by the entirety. This type of property ownership is specifically for husband and wife with the right of survivorship. When one spouse dies, the other spouse inherits the entire property. This type of tenancy is similar to the joint tenancy, but reserved for the married couple, with the estate shared equally but undivided. Community property. Several states have community property laws that control the disposition of property. Community property statutes apply more to the ownership of property rather than the form of ownership. Property interest is determined largely by the date of purchase relative to the date of marriage between the parties and which party's money was used to purchase the property. Property purchased after the date of marriage with money provided by both parties would be subject to the community property laws of the state. If one of the parties purchased a car using money earned prior to the date of marriage, the car would not be subject to the community property laws of the state. Condominium. This is a type of ownership recognized in the marketplace. The owner of a condominium owns the airspace between the walls of the specific unit, along with an interest in all the land in the complex, which includes all the common areas. Cooperative. This is also a specific type of ownership. The owner of a unit in this type of ownership owns stock in the corporation. The corporation owns the real estate. This issued stock represents the owner's living unit. The management of the real estate is controlled by an elected board of directors acting for the corporation. Timeshares. This type of limited ownership is similar to a lease, but has a specified period of occupancy of the real estate. The timeshare owner has the right to use for a specified period of time, subject to the rights of the other timeshare owners in the complex. An elected board of directors manages the timeshare complex. End of page.